Hello, my name is Jim Toot, and I'm an Associate Professor of Political Science at Central Virginia Community College. In this video, we'll discuss the courts, Part 2, the power of the U.S. Supreme Court. In Federalist Number 78, Alexander Hamilton described the courts as the least dangerous branch of government. Yet they do possess considerable power. For example, because of the court's 5-4 decision in 2002, the more than 7 million public high school students engaged in competitive extracurricular activities including cheerleading, Future Farmers of America, Spanish Club, and choir can be required to submit to random drug testing. The federal court's most significant power is judicial review. Exercising it, they can refuse to apply a state or federal law because in their judgment it violates the U.S. Constitution. 40 years after Marbury versus Madison, the court did not overturn For 40 years after Marbury versus Madison, the court did not overturn a single law of Congress, and when it finally did, it was the Dred Scott decision which dramatically damaged the court's power. The court ruled that people of African descent who were slaves and their descendants, whether or not they were slaves, were not protected by the Constitution and could never be U.S. citizens. The court also held that the U.S. Congress had no authority to prohibit slavery in the federal territories. The pace of judicial review picked up in the 1960s and continues to this day. The Supreme Court has invalidated an average of 18 federal laws per decade. The court has displayed even less compunction about voiding state laws. For example, the famous Brown versus the Board of Education of Topeka, Kansas desegregation case overturned statutes from Kansas, Delaware, South Carolina, and Virginia that either required or permitted segregated public schools. The average number of state and local laws invalidated per decade is 122, although it has fluctuated from a high of 195 to a low for the period of 2000 to 2008 of 34. Judicial review can be seen as reinforcing the system of checks and balances. It's a way of policing the actions of Congress, the President, and state governments to make sure that they are in accord with the Constitution. But whether an act violates the Constitution is often sharply debated, not least by members of the court. There are three types of constraints on the power of the Supreme Court and lower court judges. They are precedents, internal limitations, and external checks. Judges look to precedent, previously decided cases, to guide and justify their decisions. They are expected to follow the principle of stare decisis, which is Latin for to stand on the decision. They identify the similarity between the case under consideration and previous ones. Then they apply the rule of law contained in the earlier case or cases to the current case. Often, one side is favored by the evidence and the precedents. Precedents, however, have less of an influence on judicial power than would be expected. According to a study, justices interpret precedent in order to move existing precedents closer to the preferred outcomes and to justify new policy choices. Precedents may erode over time. The 1954 Brown school desegregation decision overturned the 1896 Plessy decision that had upheld the constitutionality of separate but equal facilities and thus segregation. Or they may be overturned relatively quickly. In 2003, the Supreme Court, by 6-3, struck down a Texas law that made homosexual acts a crime, overruling the court's decision 17 years earlier upholding a similar anti-sodomy law in Georgia. The previous case was not correct when it was decided, and it is not correct today, Justice Kennedy wrote for the majority. The earlier case was Bowers versus Hardwick, and it was overruled by Lawrence versus Texas in 2003. Judges may disagree about which precedents apply to a case. Consider students wanting to use campus facilities to pray for prayer groups. If this is seen as violating the separation of church and state, they lose their case. If it is seen as freedom of speech, they win it. Precedents may allow a finding for either party, or a case may involve new areas of the law. For the courts to exercise power, there must be a case to decide, a controversy between legitimate adversaries who have suffered or are about to suffer in some way. The case must be about the protection or enforcement of legal rights or the redress of wrongs. Judges cannot solicit cases, although they can use their decisions to signal their willingness to hear more cases in particular policy areas. In addition, justices can't give an opinion on a hypothetical case, because in the case of hypotheticals, each case is different. Judges, moreover, are expected to follow the Constitution and the law despite their policy preferences. In a speech to the Bar Association, Supreme Court Justice John Paul Stevens regretted two of his majority opinions, saying that he had no choice but to uphold the federal statutes. The executive and legislative branches can check or try to check judicial power. Through their authority to nominate federal judges, presidents influence the power and direction of the courts by filling vacancies with people likely to support their policies. Presidents may object to specific decisions in speeches, press conferences, or written statements. In his 2010 State of the Union address, with 6 of the justices seated in front of him, President Obama criticized the Supreme Court's decision that corporations have a First Amendment right to make unlimited expenditures in candidate elections, Citizens United versus the Federal Election Commission. Presidents can engage in frontal assaults. Following his overwhelming re-election victory, President Franklin D. Roosevelt proposed to Congress in February 1937 that another justice be added to the Supreme Court for each sitting justice over the age of 70. This would have increased the number of justices on the court from 9 to 15. His ostensible justification was the court's workload and the ages of the justices. Actually, he was frustrated by the court's direction, which gutted his New Deal economic programs by declaring many of its measures unconstitutional. Congress can check judicial power. It overcomes a decision of the court by writing a new law or rewriting a law to meet the court's constitutional objectives without altering the policy. It can threaten to, and sometimes succeed in, removing a subject from the court's jurisdiction or propose a constitutional amendment to undo a court's decision. Indeed, the first piece of legislation signed by President Obama overturned a 5-4 Supreme Court 2007 decision that gave the woman a maximum of 6 months to seek redress after receiving the first check for less pay than her peers, Ledbetter versus Georgia Tire and Rubber Company, named after the woman who at the end of her 19-year career complained that she had been paid less than men. The Lilly Ledbetter Fair Pay Act extends the period to 6 months after any discriminatory paycheck. It also applies to anyone seeking redress for pay discrimination based on race, religion, disability, or age. The Constitution grants Congress the power to impeach judges, but since the Constitution was ratified, the House has impeached only 11 federal judges and the Senate has convicted only 5 of them. They were convicted for such crimes as bribery, racketeering, perjury, tax evasion, incompetence, and insanity, but not for wrongly interpreting the law. The Supreme Court may lose power if the public perceives it is going too far. Politicians and interest groups criticize, even condemn particular decisions. They stir up public indignation against the court and individual justices. This happened to Chief Justice Earl Warren and his colleagues during the 1950s for their school desegregation and other civil rights decisions. External pressures is also applied when the decisions, composition, and future appointments to the Supreme Court become issues during presidential elections. Judges have power because they decide cases. They interpret the Constitution and laws and select precedents. These decisions often influence, even make public policy, and have important ramifications for social conflict. For example, the Supreme Court has effectively established the ground rules for elections. In 1962, it set forth its one-person, one-vote standard for judging electoral districts, Baker v. Carr, 1962. It has declared term limits for members of Congress unconstitutional, and it has upheld state laws making it extremely difficult for third parties to challenge the dominance of the two major parties. How willing are judges to make public policy depends in part on their judicial philosophies. Some argue that justices' behavior is largely determined by their individual policy preferences. Some follow judicial restraint, deciding cases on the narrowest grounds possible. In interpreting federal laws, they defer to the views expressed in Congress by those who made the laws. They shy away from invalidating laws and the actions of government officials. They tend to define some issues as political questions that should be left to other branches of government or to the voters. When the Constitution is silent, ambiguous, or open-ended on a subject, for example, freedom of speech, due process of law, and equal protection of the laws, They look to see whether they practice the practice being challenged is a long-standing American tradition, and they are inclined to adhere to precedent. Judicial restraint is sometimes paired with strict constructionism. Judges apply the Constitution according to what they believe it was its original meaning as understood by a reasonable person when the Constitution was written. Other judges follow a philosophy of judicial activism, although they prefer not to call it that. Activist judges are willing to substitute their policy views for the policy actions or inaction of the other branches of government. Judicial activism is often paired with loose constructionism, viewing the Constitution as a living document that the founders left deliberately ambiguous. In interpreting the Constitution, these judges are responsive to what they see as changes in society and its needs. A plurality of the Supreme Court found the right to privacy implicit in the Constitution and used it to overturn a Connecticut law prohibiting the use of contraceptives, Griswold versus Connecticut. The justices later used that privacy right as a basis for the famous Roe v. Wade decision. One doesn't have to believe that the justices are politicians in black robes to understand that some of their decisions are influenced, if not determined, by their political views. Judges appointed by a Democratic president are more liberal than those appointed by a Republican president on labor and economic regulation issues, civil rights and civil liberties issues, and criminal justice. Republican and Democratic federal appeals court judges decide differently on contentious issues such as abortion, racial integration and racial preferences, church-state relations, environmental protection, and gay rights, and more recently on immigration. On rare occasions, the Supreme Court renders a controversial decision that graphically reveals its power and is seen as motivated by political partisanship. In December 2000, the court voted 5-4, with the 5 most conservative justices in the majority, that the Florida election code's intent of the voter standard provided insufficient guidance for manually recounting disputed ballots and that there was no time left to conduct recounts under constitutionally acceptable standards. Bush versus Gore, 2000. This decision determined the outcome of the 2000 presidential election. In this section, we addressed how judicial review originated, how it is exercised, and what its effects are. We described the power of the courts, especially at the Supreme Court, and how it may be constrained by precedent, internal limitations, and external pressures. Justices make policy and are influenced by their ideological views and judicial philosophies.